Welcome back. Let's get more now on a potential compensation scheme for car finance customers. Let's bring in Sam Ward, Director and Chief Investigator at Sentinel Legal. Great to talk to you today, Sam. So just remind us what the Supreme Court decided on Friday and what has been decided over the weekend by the Financial Conduct Authority.
So the Supreme Court on Friday decided that the non-disclosure of commissions and the non-disclosure of the relationship between the car dealer and the car finance provider created an unfair relationship for consumers, and they awarded Mr. Johnson the full commission back plus interest. So the FCA has come out today off the back of the Supreme Court judgment and said that they will now consult with the banks on a redress scheme that could go live in 2026, which means that UK drivers could be getting finally the compensation that they deserve.
Now, this isn't across the board, as I understand it. It's not everybody who got their car on finance, is it? It's just those where the motoring organisation, the person that they bought the car through, took a particularly large commission. Is that right?
No, it's actually anyone who taken a car out on finance and they were not told the information in regards to the commission, that the commission existed, that the relationship between the car finance lender and the dealer existed in such a way that would make them unable to be impartial. What we saw, or what we've seen on a lot of these car finance agreements, that there's no mention of the commission and there's just some sort of boilerplate wording that said we may pay a commission. And that's exactly what the Supreme Court said is unfair. Now, in Mr. Johnson's case, 55% of his overall interest was paid as a commission, and the Supreme Court said that this was a particularly alarming point that made it even more unfair.
So how much money would consumers be able to get back? Is it just a proportion of the commission?
Well, everything that we've seen today through taking these cases to court or Sentinel Legal, we've seen that the average consumer is getting anywhere from £1,500 to £1,800. And what Mr. Johnson was awarded in the Supreme Court on Friday was the full compensation payment of all of his commission, plus what the Supreme Court called a commercial interest rate. And the FCA has come out today and said that they're looking at what the average base rate would have been over the last few years, and then adding 1%. So it could be in the region of 4% statutory interest on top of the commission.
So when the scheme is finally announced, will it be the case that motorists themselves are going to have to chase this up, or will the organisations be getting in touch with them?
Well, this is the key point, and this is what we really want to stress to both the FCA and consumers, that the FCA started investigating these commission structures way back in 2017, and after 8 years of delay, the worst thing the FCA could do now is rush a scheme that risks letting the banks off and giving themselves their own oversight. Consumers deserve real redress, not watered-down settlements, not delays, and definitely not another round of a self-policing policy. So this is the time for the FCA to take their time, not rush anything, speak to claimant-focused law firms that have spent the last years uncovering this and dismantling this commission piece and looking at the evidence so that a fair and appropriate redress scheme goes live that is appropriate for the consumers.
The FCA are also saying, though, that consumers shouldn't necessarily go through third parties or claim organisations, that they should be able to contact their lender directly.
Absolutely. Consumers can email their lenders. They can do that via email. They can do that via post. Most lender websites tell them how to claim, but if we're completely honest, we would not be having this conversation. The Supreme Court would have not made its ruling on Friday without claimant law firms bringing this to the attention, going through the county courts, having the ability and the confidence in their disclosure and the evidence that they've found to appeal this and bring it to the FCA's attention. The FCA looked at this in 2017. We're nearly 10 years on and we still don't have the redress scheme, the compensation that clients deserve. So if that has to come via law firms, then so be it.
Sam Ward, the Director and Chief Investigator at Sentinel Legal. Good to get your thoughts this evening. Thanks very much for joining us.